Hello, this is Brian Ka with another video to help you pass the California baby bar and the bar exam. So we're going to do another remedies question, and this is from February of 2017, and this is question 2. So the call of the question says, what is the likely outcome of Betty's lawsuit, and what remedies can she reasonably seek? So even though this is a remedies question, they're asking what is the likely outcome of Betty's lawsuit? So here, likely outcome of Betty's lawsuit. And that's the first thing, and we're going to have to talk about remedies, right? So here, I like to read a paragraph right above the call of the question next, because they usually hint at where you should be looking at, what theories that you should think about or write about to solve this legal issue. So right above that, you can find that Betty has tried to sell the condominium, but has been unable to obtain offers of more than $160,000, partly due to the disclosure of the murder and the lack of a parking space. Betty has sued Steve for fraud. So it looks like Betty has sued for the defendant named Steve, right? It's Betty versus Steve for what? It's for fraud. Okay, so it looks like since they're looking for what's the outcome of Betty's lawsuit, her lawsuit was based on fraud or misrepresentation. And we have to try to figure out, once we can establish um, whether there was fraud. And in this case, obviously, there's going to be fraud, but obviously you can't just write that conclusory sentence saying Steve is liable for fraud and here are remedies. You can't do that. They're trying to get you to analyze whether uh, there was fraud, and in order for us to do that, we're going to have to know the basic elements for fraud misrepresentation. Then we're going to have to get into things like expectation, damages, um, consequential, if it applies, things like reliance and so forth, right? So let's try to read the fact pattern and see where this story or fact pattern is going to take us. So here, Steve agreed to convey his condominium for Betty for $200,000 in a written contract signed by both parties. Okay. During negotiations, Steve told Betty that although there was no deeded parking along with the unit, he was allowed to park his car on an adjacent lot for $50 a month. Okay, so Steve is selling to Betty a condominium that was worth 200,000, a valid K, and a valid contract. There's no dispute here. There was a valid contract, and they're letting you know. Valid K and signed by both parties. Okay, so obviously, um, we're not going to have a written contract signed by both parties. We're probably not going to have statute of frauds issue either. Okay, so here, no deeded. Steve told Betty that although there was no deeded parking along with the unit, he was allowed to park his car on an adjacent lot for $50 a month. So parking lot, he said that you can get one for $50 a month, right? And this happened during negotiations. Steve stated that he had no reason to believe that Betty would not be able to continue their arrangement. Parking was important to Betty because the condominium was located in a congested urban area. Okay, so the first issue is parking. And he made a statement of present or past fact. And we're going to have to probably see if this here, it seems like if this statement here was fraudulent, right? So on June 1st, the conveyance took place. Betty paid Steve $200,000. Steve deeded the condominium to Betty, and Betty moved. Okay. She immediately had the entire unit painted, replaced some windows, and added a deck. The improvements cost $20,000. Improvements. She also spent $2,000 to replace with a shower. Okay, so it looks like on top of 200,000, I guess this is going to be handy when we talk about money damages or legal damages. 20,000 in improvements, maybe in reliance of the contract. Another 2,000. We can add if we have to talk about money damages, in which and we probably will. 2,000 to replace it with a shower, and leaving the condominium with 2 showers and no bathtub. Okay, so we have 200,000, 20,000, 2,000, and 200,000. So a total of 222,000 that she spent. 222,000 she spent. Okay, this is just a mental note to myself. On August 1st, Betty's discovered that the owner of the adjacent parking lot was about to construct an office building on it and was going to discontinue renting parking spaces. Uh-oh, so the problem starts here. So on August 1st, which was 2 months after the conveyance took place, this parking lot issue for $50 a month starts to have issues. Okay. Now, they were going to construct an office building on it. So she was going to have to, they were going to discontinue renting parking spaces. The thing is here that Steve had known about this. Steve knew about discontinuation, right? Right away, I mean, this is telling you that we're going to have to discuss whether there was fraud when it comes to the parking space. Okay. And she quickly investigated other options and discovered that she could rent parking a block away for 100 a month. So replacement was 100. So she was gonna lose $50 a month because the market value for a replacement was 100. She was promised 50, and the difference between 100 and 50 is obviously 50. Okay, so at the same time, she also found out that immediately before Steve had bought the condominium, the previous owner had been murdered on the premises. Steve had failed to tell Betty about the incident. Okay, so when we organize this question, I guess since we have to likely find out the outcome of Betty's lawsuit, and she's suing for fraud and misrepresentation, the misrepresentation that Steve made were twofold. The first one, obviously, was parking. The second was the murder, which took place on the premises, and Steve had failed to tell Betty about the incident. Okay, so we're gonna have to uh, know the elements of fraud, and after we do the role statements, we're gonna have to do parking, whether um, his statement about the availability of parking space was fraudulent. And we're going to have to also talk about whether failing to disclose the murder that took place was fraudulent also. And I think that after that, there's telling us that Betty tried to sell, but she was only able to get a $160,000 offer, which is $40,000 less than what she bargained for. But she also lost, some, or was going to lose money every month on parking and the Reliance damages that she lost as a result of selling for this price. So um, she's basically losing 160,000 plus $22,000 she spent in the reliance of the contract. So that would be $182,000 that she was going to lose as a result. But anyway, for fraud, um, first, it's usually a false statement of past or present fact um, that was made with scienter, meaning Steve knew about this false and false falsity, uh, right? False knew about this falsity that was material to the contract, which induces reliance. I think that's pretty good for misrepresentation. And we're gonna just plug in the facts, try to argue both sides. Whenever you see an arguable issue, and we're gonna have to conclude. So the thing is here, what's confusing is we're gonna have to do this twice because you know we're gonna have to separate whether there was a fraudulent uh, statement made with parking or made with murder. I think that would be better in terms of organization instead of trying to mix them up together. So for parking, the facts tell you that Steve stated that he had no reason to believe that Betty would not be able to continue that arrangement, right? Now, in the third paragraph, they tell you that there was going to be a construction and they were going to discontinue renting parking spaces. But Steve had known about these plans before the sale, and that's the gold nugget, right? So he made a false statement. He had the knowledge of falsity because they're telling you here, straight up, hey, like he knew that they were going to do that, construct a building, thus discontinuing the available parking spaces. Now, they're also giving you facts that you can use for materiality because here it says parking was important to Betty because the condominium was located in a congested urban area. They're telling you it was so important for Betty. It was material, Not having that parking space would have made her think twice. And because of that parking space, it induced her to rely on that fact. And, summing up the argument for parking, we can probably conclude that yes, there was fraud for the statement on parking space, right? Now, as for murder, um, here, whether not disclosing murder is considered false statement depends on, I think, whether we can argue that maybe the court will say, disclosing the murder doesn't rise to the level of materiality, or it does. But in this case, I would try to argue that it was material because, as you can see, the value of the property went down from 200,000 to $160,000. This was the fair market value when Betty was trying to sell again. So obviously, that the fact that murder had taken place, um, since Steve didn't disclose it, that would rise to the level of a false statement with the center knowledge of falsity. And since that murder, just not disclosing that murder, um, decreased the fair market value of the home to 160,000 from 200,000, it was material, and it had Betty known about the murder, she probably wouldn't have purchased the property. So it induced her to rely on the failure to disclose the murder, which led her to purchase the property for 200,000. So for both parking and murder, um, conclude murder Yes, fraud. So we're gonna have to answer number one, what was the likely outcome of Betty's lawsuit based on fraud? The outcome is that, for parking lot, that fraudulent statement and all these facts that we uh, plugged in ends up being a good case for fraud, and Steve would be liable even under murder. The fact that he didn't disclose something that would have been material to the contract, and in which that failure to disclose induced reliance, and Betty relied on that failure to disclose and ended up purchasing the property. So even under murder, she would be successful in suing Steve. So that completes number one. And I think we answered it. We don't need to get into any other tort. They told us that um, Betty has sued. These are exact words from the fourth paragraph. It says Betty has sued Steve for fraud, right? So we don't need to try to get into any other tort. Um, this is just a fraud issue. And since this was like a tort slash remedies question, we did have to analyze fraud, know the elements, plug in the facts, separate parking issue and murder issue for organization and clarity, which led us to conclude that Steve would be liable for fraud under both of these theories. Okay, that wasn't too bad. Now we're gonna have to do remedies section. Okay, so if he is liable for fraud, then what are the remedies that we can seek? Now that's not going to be too hard because we already have the amount in which she was expected to get a property worth $200,000, and the to make the plaintiff whole, had the contract been fully performed, or um, as if the uh, as if there was no breach, or another way to calculate would be to use the contract price minus the fair market value, which would be $40,000. But usually, for expectation or compensatory damages, I use whether there was the elements that I use are number one, whether it was um, number one, we have to look at the causation element of both but for and foreseeability, and plug in the facts, but for Steve failing to disclose these issues, she would not have suffered $40,000 loss, and it was foreseeable, which is probably arguable for Steve also. But that's going to be a weak argument because it's foreseeable when you don't talk about the murder that had taken place at the property. The the property value is obviously going to go down, and not revealing the true nature of what was happening as as far as the parking lot was concerned, that was going to be obviously foreseeable, that she would have to she would lose money on that also. So um, that we can talk about causation, but for foreseeability. Um, what's the other thing? You know that we have to talk about mitigation, um, whether Betty sufficiently mitigated her losses, and there's really no argument for um, Steve here. She tried to sell it as soon as she could. There's nothing that she could have done to mitigate her losses. The next one is whether these numbers are certain. Um, Obviously, that fair market value that she received was at 160,000. That's a certain figure. Also, the $200,000 was the amount that they contracted for. So obviously, the certainty aspect will be satisfied without much argument here also. So I would say mitigation certainty, talk about before, and importantly foreseeability. Usually I like to either talk about this in the expectation compensatory section, unless the, the facts call for a consequential damages, um, you know, and consequential damages, the biggest thing again is foreseeability. Uh, I feel like there's no consequential damages here. The thing is, we can talk about the loss in property value, then we can talk about the parking space, go through each element again, and argue that um, he owes her, $50 per month. That's the difference between the cost of replacing 100 and what uh, he originally said, which was 50. But this is not going to be like forever for the rest of her life or his life. And the court will probably say, calculate um, a figure so he can pay this difference at once instead of paying $50 per year every year until 80 years later. Now, another thing that seems to me that we can argue is reliance damages. Here, in reliance of the contract, she spent 20,000 and 2,000 to replace the shower. Now, Steve could argue, these are costly improvements, and that replacing a shower, was not necessary at all because the bathtub was already in a good condition. He can make stuff up, but in the end, because she was relying on the contract and this money was spent in reliance of the $200,000 price she paid without the parking issue and the disclosure of murder issue, I would argue that under reliance damages, she'll probably get 22,000. All right. I don't see any restitution issue. Um, maybe we can talk about punitive damages. It needs to rise above the level of negligence, such as fraud, malice. It needs to be proportional to the loss. And I think that, it's worth a try here to talk about punitive, because under contracts, punitive damages are not allowed, since we're talking about fraud under torts, and because there was a knowledge of falsity, but he did this knowing that there was a parking lot issue and murder issue, and this is obviously, it rises to the level that's higher than negligence. So, with intent to defraud, we can tell the court that Steve owes her this, the difference plus reliance plus hand him a punitive damage, since, we're going to have to make an example out of him so that this doesn't happen again in the future for other parties. And with that, I don't think I missed anything. One thing about remedies, I think that the more you do them, uh, it gets easier, just like any other subjects. But one thing about remedies is that it'll help you for things like contracts essays and any torts essays, because for those two, even if it's just all contracts, you're going to end up talking about remedies in the end. Like, you're going to have to talk about UCC, common law, talk about offer acceptance consideration. You're going to have to talk about pro evidence, statute of frauds, whether there was a breach, and then anticipatory repudiation, go into defenses to performance like impossibility and so forth. And then you're going to always talk about remedies. So, um, you know, I think it's very useful. And I've also heard some people say that remedies is one of the most important, you know, aspect of law school, because when you're practicing, it all comes down to calculating the damages for your client. And if you don't know how to calculate, what are you going to ask for, right? So with that, we did another remedies question, and again, this was on a scale of 1 to 10. I would say this was like a 5. It was easy. Maybe I missed something, uh, but if I did, I'll leave something in the description saying, I left something. But for now, the way I see it, doesn't seem like I missed anything. But anyhow, I hope this video was another helpful video for you. And I thank you for watching, and I'll see you in the next video.